Chapter 4 Codes, Code of Civil Procedure, Sec. 17. Legal systems of procedure in this country. The systems of legal procedure in this country may be divided into three classes. In some states the common law practice, as regulated by the rules of King's Bench and Chancery at the time of our Revolution, with such modifications and changes as have been made from time to time by the courts and legislatures, is still followed. In other states there is what is sometimes called either a quasi-code or practice act, which consists of brief statutory enactments governing the more important matters relating to practice. The majority of the states have adopted what is termed the reformed procedure or code procedure. Sec. 18. What does code mean? Code in its elementary sense means an ordinary collection, system, or digest of laws, a collection of laws by public authority, originally used in connection with the code made by Theodosius, and later applied to Justinian's Code. Justinian's Code was prepared by about 16 jurists appointed by Emperor Justinian. It was largely a compilation of the existing law, with such changes and modification as were deemed necessary. It contained 50 books, and was given the force of law on December 30th, A.D. 533. It was a code written in the form of a treatise, each book covering the different topics of the law. The code was so prepared as that it would be a scientific treatment of the general principles of the law, such as could be placed in the hands of students, but covering all important subjects for practical purposes as well. Sec. 19. Pleading defined. An old definition of pleading given in Reed v. Brookman, 3-term Rep. 159, is a statement in a logical and legal form of the facts which constitute the plaintiff's cause of action or of the defendant's ground of defense. This definition is not broad enough to embrace a demurrer which was excluded upon the theory that it was not a plea, but was merely an excuse for not pleading. 42. Blackstone defines pleadings as the mutual altercations between the parties. Pleadings and pleading are distinguishable from each other. Pleadings are the instruments by means of which the making of the formal statement is done. The Ohio Code originally defined the term as follows: the pleadings are the written statements by the parties of the facts constituting their respective claims and defenses. This does not now appear in the Code. Plea, according to Stephen, was anciently used to signify suit or action, and gave rise to pleader, and to plead, the primary meaning of which was to litigate. Later in English law it was considered in the more limited sense of making allegation in a cause. This was the origin of pleading. Sec. 20. Code pleading. The prefix, code, embraced that system which prevailed at common law, and depended for its authority upon the precedents and usages as determined by courts of common law, and established by their adjudications and preserved by report, as well as all general principles and rules of law, as distinguished from those established by legislative sanction. But applying the term to pleading and procedure, code pleading, has reference to the reformed Code of Civil Procedure, and the system of pleading prevailing there under sanction of precedent and statutes. It includes not only the mere pleading in a cause of action, or the science of stating a cause of action, but the whole system of procedure established by the Code. It denotes any system of pleading whose principles have been reduced to the form of a statute. While there is very general similarity in the codes of the several states, still the code pleading of one state can properly enough be regarded as standing by itself, a distinct system independent of the code pleading of every other state. The new system is built out of the old. Much is discarded, but rarely is new material introduced. And not only was the code pleading built out of the older systems, it was designed for the same purpose which they sought to serve: the administration of the substantive common law of England. Sec. 21. Some historical facts with reference to codes. There were a number of attempts in England towards reform in procedure, but the first step in that direction was taken in the United States. The first code was adopted in New York, in 1849, and was prepared by a commission appointed in conformity to a constitutional provision for readjusting courts. It was probably almost entirely prepared by David Dudley Field, who spent many years and thousands of dollars in his campaign for a code. The code drawn by Mr. Field was not adopted as a whole in the first instance, but was amended and added to from time to time, so that for this reason it was probably not as perfect a code as the one adopted in Ohio. The general spirit and policy of the New York Code, however, together with the very terms of many of its most essential provisions, have been incorporated into the codes of the other states adopting this method of procedure. The reform in the systems of procedure could not be brought about without constitutional authority. Article 14 of the Constitution of Ohio of 1851, provided that 3 commissioners be appointed, to revise, reform, simplify and abridge the practice, pleadings, forms and proceedings of the courts of record of this state, and, as far as practicable and expedient, they shall provide for the abolition of the distinct forms of action at law, now in use, and for the administration of justice by a uniform mode of proceeding, without reference to any distinction between law and equity. Objection was made to the mode of appointing the commissioners, the fear being that they would be under the influence of the lawyers, it being contended that they ought to be elected by the people. The commissioners in the formation of the code drew chiefly from the New York Code, and also from those of Kentucky, Missouri, Indiana, Massachusetts and other states where the Code of New York had been to a great extent followed. The commissioners appended to various sections of the code very extended and full explanations of the changes which they proposed. This constitutes what is called the Code Commissioners' Report. They also reported a large number of forms of summons, writs and pleadings and answers in the various actions. While the forms which they presented were not adopted with the Act, they are nevertheless entitled to respect and have been followed. The next step taken with reference to the Ohio Code, was in pursuance of an Act of the General Assembly, passed March 27, 1875, providing for the revision and consolidation of the statutes of Ohio. That was a very proper step considering the time which had elapsed since the adoption of the Code, and the many changes which had been made. But in this revision it was not the purpose to change or add to the Code of Civil Procedure of 1853, but the design was only to harmonize the general system of laws which had been passed during the 23 years previous. In pursuance of this provision of the Constitution, the legislature of Ohio on March 4, 1852, passed an Act, Sec. 1 of which provided for the appointment of 3 commissioners, and prescribed their duties in the language of the Constitution. The work of this commission was confined to civil procedure. They did not touch criminal procedure, or probate practice. Neither did they have anything to do with justices' courts, as they were not courts of record. This commission performed their duties and reported a code to the legislature which was passed and went into effect July 1, 1853. The commissioners who were appointed for this purpose reported the results of their labors on the statutes during the year 1879, and their report was acted upon and approved by the General Assembly in 1880, and the statutes thus revised and prepared by them were styled and are known as the Revised Statutes of 1880, and form a very important epoch in the history of the Ohio Code. In the report made by that commission it was suggested that there be no changes made in any part of it, unless clearly necessary. In this way, they said, the Ohio Code will become staple, and the fruits of this undertaking be preserved for a great number of years. This recommendation has been pretty generally heeded. No material changes have been made since the beginning. In this day of public cry for reform, it may be truly said that the code system of procedure as it stands now is the best mode ever devised. The New York Code was adopted in 1848, Missouri was the next state, adopting a code in 1849. California adopted a code in 1850, in 1872 that state adopted a civil code, a penal code and a political code. Kentucky's code was adopted in March, 1850, Iowa, in 1851, Minnesota, in 1852, Indiana, in 1852, Ohio, in 1853, Oregon, in 1854, Washington, in 1854, Nebraska, in 1855, Wisconsin, in 1856, Kansas, in 1859, Nevada, in 1861, Dakotas, in 1862, Idaho, in 1864, Montana, in 1865, Arizona, in 1864, North Carolina, in 1868, South Carolina, in 1868-1870, Arkansas, in 1868, Wyoming, in 1869, Florida, in 1870. In this state, however, the code was repealed and the old system re-established. Utah adopted a code in 1870, Colorado, in 1877, Connecticut, in 1879, Oklahoma, in 1890. The state of Iowa has more recently adopted what may be classed as a complete code of pleading and procedure. Sec. 22. Reform in England by the Judicature Act. Notwithstanding the fact that numerous attempts at reform were made in England, nothing was in fact done until long after this country set the example. In 1873 the English Judicature Act was passed, which swept away the common law system of pleading and procedure more completely than we had done in this country. The chief aim was to establish a simple, uniform law of procedure for all of the superior courts. It created a civil action with wider scope than the American action, as it included admiralty. It simplified pleading, provided for rules of court governing pleading, and aimed to effect a unification of the substantive law,